In the following, I would like to present to you some more details about the actual filing of an international application under the PCT. Now, when you submit your international application to the receiving office, you need to include certain elements in the package that you submit to the office. So what are these elements? Well, you need to start off submitting a request form, filling in the request form, and I'll talk about these details later on. You need to include a description, you need to have claims, you need to have an abstract, which is a summary of your claimed invention. You, in most cases, will also have drawings. Now, drawings aren't an absolute must to get an international filing date, but imagine a case where you have an invention in the mechanical area. It's very hard to disclose your invention without also submitting a drawing explaining what your invention is all about. However, if it's in the biotech or chemical area, maybe you won't have any drawings. So drawings aren't an absolute must, but remember, if you need drawings, you need to include them at the time of filing. If you submit them afterwards, you will, in all likelihood, get a later international filing date. And then there are two special cases which only concern applicants who file in the area of biotech. The first one is if your invention concerns a sequence. A sequence is a DNA structure. So if you need to disclose that sequence, the PCT requires that you include what's called a sequence listing. And that sequence listing needs to be in compliance with Annex C of the PCT administrative instructions. Sounds harder than it is. Actually, if you use a software which is provided free of charge to applicants to create these sequence listings, like the patent-in software, for instance, it automatically creates a sequence listing which complies with that particular standard. So you just need to remember that you need to submit that together with your international application. Another possibility, again in the biotech area, would be that you are disclosing biological material. Now, in that case, a lot of the national offices which are part of the PCT under their national law require that it's not good enough that you simply describe the biological material in your description, but you need to submit a live sample of this microorganism. This has been regulated by a treaty called the Budapest Treaty. And what this treaty basically says is you need to make a deposit of this microorganism with a depository, a recognized depository institute, and then this one deposit will be accepted by all the member states of the Budapest Treaty. Now, admittedly, not all PCT member states are also member states of the Budapest Treaty, but those states where an applicant in the area of biotech would most likely enter the national phase, before those offices, they are usually all part of the Budapest Treaty. So you need to comply with the requirement of the Budapest Treaty by submitting a live sample of your biological material, and you need to make sure that you do so before the actual filing of your PCT application. Because afterwards, when you submit your PCT application, you need to include a reference to this deposit in your international application. There are essentially two ways to include this reference. One is to have it as a separate paragraph of the description. You simply draft a paragraph of the description and you include three pieces of information which you need to include. The first element is the date of the deposit, with which institute you have deposited the biological material, and the number that was given to you by the institute when you made the deposit. Alternatively, rather than drafting this separate paragraph, you can also include a form which is called PCT RO 134, and you can include that form as part of the description. Usually applicants make it the last page of the description, and in that form you can provide again the pieces of information that I just mentioned. So these are really the elements of the international application. Together with your international application, sometimes also you wish to submit other documents to the receiving office. And one of the elements that you could accompany your application with is, for instance, a translation. Now, this would only be needed in a case where the language of filing of your international application is not a language accepted by the International Searching Authority. And in this case, you need to submit a translation into a language accepted by the International Searching Authority. Another very common scenario is that maybe applicants would like to include powers of attorney because they don't submit the application themselves, but they hire an attorney, an agent to represent them. The agent submits the application, and in order to show that he's entitled to represent the applicant, he submits also powers of attorney signed by the applicants. If an applicant already has a priority document and he has obviously a priority claim in his international application, he might also wish to submit a priority document. Now, the starting point really is to fill in the request form. And the request form really comes in several flavors. The more traditional way to fill in a request form and to prepare a request form is to use a PDF version of the request form, which you can find on our internet site. You can fill this in on your computer screen, print it out, and then do a paper submission. Now, of course, the majority of our applicants today do not submit their international applications anymore on paper. Instead, they submit international applications in electronic form, and there are quite some advantages, not least, for instance, that you get a fee reduction if you submit your applications electronically. So it's much more common today to file electronically, and in order to fill in the request form for electronic filings, you can use software which is available. One piece of software is called the PCT Safe software, which was developed by WIPO and is also freely available to applicants, and they can use it and submit their applications with the help of that software. Other offices have produced similar software packages to allow applicants to submit request forms and international applications in electronic form. When you file your international application, you automatically designate all states which can at that time be designated under the PCT. Those states where you later on want to enter national phase, you need to take certain steps to do so by the end of 30 months. Those designated states where you have no interest to obtain patent protection later on, you simply do not enter the national phase. But at the time of filing, you automatically designate all states. And it's also an all-inclusive designation, which includes protection for patents, but it also includes protection for utility models, inventor certificates, or similar titles. It's all done automatically, and you do not need to take particular decisions at the time of filing. It's also a designation for a particular country as a national office, or if it's part of a regional arrangement, you also designate that state as part of that regional arrangement. Again, it's automatic. The decision how you will continue later on needs only to be taken at 30 months when you enter the national phase. There's one important exception to the automatic designation of all states, and that concerns 3 particular states, namely Germany, Japan, and Korea. The reason for this exception is that under the national law of these 3 countries, there are provisions which basically bar that there are 2 co-pending applications for those particular countries. So for instance, if you have an earlier application that you have filed with the Japan Patent Office, and you're subsequently filing a PCT application, which of course would include automatically the designation of Japan, right at that point you have 2 co-pending applications. And since Japanese national law does not particularly like that, there is a provision under Japanese law which says at least at 15 months from the priority date, one of the 2 applications will be considered withdrawn, and under the national system it's always the earlier application which will be considered withdrawn. It's considered withdrawn, it's not considered not to have been submitted, which is an important distinction because this still allows you to claim priority of that earlier Japanese application in your PCT. But it will keep you from further processing that initially filed national application if it's considered withdrawn. And what applicants would have to do in this case, they would have to enter the national phase in Japan at 30 months and continue with the processing of the application at that stage. This can, in certain instances, be a little inconvenient. Imagine a situation where you had filed your national application, you were already pretty close to patent grant, and all of a sudden it's considered withdrawn. You need to enter national phase again at a later time and start the processing from anew again at this point. So this is inconvenient. You don't lose rights, but it's inconvenient, and that's why these states have made a reservation under the provision that was introduced in 2004 for the automatic and all-inclusive designation of all states. So essentially, what you need to know, if you file a PCT application and you have a priority claim to one of those national, or an application for one of those national offices, Germany, Japan, and Korea, and you claim priority of that in your PCT, you can exclude the designation of that particular state in the PCT application. Theoretically, you could also withdraw a designation of a state, but I would be rather cautious about doing that. I actually do not see a particular reason why any applicant would wish to withdraw a designation, so be careful about even considering this. The choice of the type of protection that you ultimately would like to obtain is postponed until national phase entry. I mentioned this earlier. So when you enter the national phase, let's say in China, it's at that point in time that you need to decide, do I want a patent for China or do I only want a utility model? You have the two options in the case of China. But you would have to tell the Chinese office at the time of national phase entry which one you want. If you do not inform the office one way or the other, the default, so to speak, will be patent protection. PCT also allows you in the request form to include what we call parent information. This is, for instance, something that US applicants might wish to do. If they have an earlier US application of which they claim priority in the PCT, they might wish at this point to already indicate to the designated office US that they want the PCT application for the US to be treated as a continuation or a continuation in part of the earlier US case. Now, under the PCT, there are certain signature requirements. And in principle, the PCT requires that all applicants have to sign the international application. These requirements have been relaxed over time, and there is a rule now which says that if not all signatures are submitted, this is considered no longer a defect for as long as one applicant has signed the international application. So the baseline is one signature of one applicant is sufficient. Keep in mind, though, if you ever have a situation where you need to withdraw your international application or withdraw a priority claim, which also sometimes happens, at this point in time, you would need the signature of all the applicants. So if you did not provide all signatures up front, you would now have to provide them together with a notice of withdrawal. Also, if you have multiple applicants and not all of the applicants have signed the international application, if you're entering the national phase with one of the applicants who has not signed, the designated office could at that point require to furnish or the furnishing of the missing signature. Do note that if you include inventors as inventors only and not as applicants, if they're inventors only, they do not need to sign the international application. Now, of course, we also have many instances where it's not actually the applicant that signs, but it's someone who signs on behalf of the applicants. That could be, for instance, in the case of a corporate entity, a legal person, or it could be in the more unusual case of maybe an incapacitated natural person. So here really national law applies in determining who has the right to sign on behalf of the applicants. In the case of a legal entity, the question comes up, which of the employees of the company would be entitled to sign on behalf of the company? The CEO, maybe some others, but that's a question really of the applicable national law. Similarly, for an incapacitated natural person, you most likely would need a legal representative to sign on behalf of that person. And again, it's national law that would determine who has the right to sign on behalf of such an applicant. Now, in many PCT applications, what we also see is that the applicants do not actually sign at all, but it's an agent that has been appointed by the applicant that signs on behalf of the applicants. That's a very common situation when we see international application. In this instance, again, the same requirements apply, that we need at least one signature. Now, if the agent signs, he in principle would still need one signature of one applicant. And that could, for instance, be furnished on a power of attorney signed by one of the applicants. But the PCT rules take things one step further, because a lot of receiving offices have now used the possibility which is provided to them to do something what we call waive the requirement that a power of attorney needs to be furnished. So in case of such offices, it is sufficient that the agent signs the request form and he doesn't even have to submit any power of attorney anymore to the receiving office. And the receiving office will simply accept and assume that he's been properly appointed by the applicants. When you submit your international application, it needs to comply with something that we call physical requirements. So for instance, you need to use A4 size paper. You need to respect a certain line spacing. You need to have certain minimum and maximum margins in your international application, in your description, in your claims, in your drawings. You should include a file reference in all pages of your international application, and your international application needs to be numbered. There are actually 4 series of numbers that you should use. You should number through the request form. You should number through the description, claims, and the abstract. Then you have another series for the drawings, and the last one, if you have a sequence listing, for the sequence listing. You should also include line numbering or paragraph numberings in your description. Both are accepted formats for an international application. There are also some special requirements for drawings, and the details of these requirements are all contained in Rule 11 of the PCT. And I would recommend, if you are interested in more details, that you turn to the PCT Applicant's Guide, which is available on WIPO's website, and you can find a lot more details on how drawings are supposed to be done and what you need to do to submit pages of drawings. One recommendation about drawings, however, which I would like to make is that do not or try not to include text matter in drawings. The problem with text matter in drawings is, first of all, the PCT has a provision which says you should not include a lot of text matter in drawings. But quite apart from that, there is a risk if you have text matter in drawings that applicants tend to overlook to translate the text matter into drawings when they enter the national phase. And if you do not also translate the text matter into drawings, some designated offices would even take the decision you haven't furnished a complete translation, and they would therefore not accept your application in the national phase.